everybody, and welcome. My name is Riznyk with San Diego Biz Law, and I am going to help you understand contracts a little bit. Those who know me know I'm in law quite by accident, but one area other than litigation that really interests me tremendously is contracts. A contract, fundamentally speaking, is the foundation of everything that you're going to do in a relationship, whether it be a contract for a prenuptial issue with your marriage, contract with partners, a contract with a vendor. I love this area because it gives you a chance to be creative. You can buy software and you get all the details already printed in. You print it out, you charge your client $5,000. There's a contract. We don't do that. We add a lot of our own input because, as those of you who know us know, we're not just a law firm, we're also a real business consulting firm, and our background is business, not law. And so as a result, we know some of the things that can happen. I've been in business since I was 13, and I've seen hundreds, if not thousands, of contracts, and I've written a whole ton of them. And it's one of the areas that I personally find it hardest to hire a good lawyer for, because unless you have a solid business background, writing a business contract, it's kind of impossible, because you can't anticipate the problems that can occur in business if you don't know how to run a business. And I don't think that most law firms are run like a business, so as a result, they're not really a business in the sense that most other businesses are. And so they don't have the needs. I mean, they do have their own needs, but every business has needs in a certain area, and you have to understand business to understand those areas and what's required. And the reason I created this program is to help you understand some of the concepts that you should have in your contracts, what to look for and what to add. And I will state one thing. I know with the advent of the internet, a lot of things have happened. And for example, you're able to find a number of venues that will provide you with a one-size-fits-all contract. And although that kind of a contract is good as a base or a foundation for you to add to, I can also tell you those are people who have created those contracts in the past are my easiest clients in my litigation department. They've been there, saved all the money, did it wrong the first time, something went sour in the relationship, and then they turn around and now they're in litigation and they want to do it right. And what they did wrong was not to personalize that contract, not to add what should be added. And here's a good thing. A contract is basically a blank piece of paper wherein you add what is going to be in there and what's going to control. The most important thing I can tell you about a contract, even if you're writing it yourself without a lawyer, is to think of everything that can possibly go wrong and address it. And some of the things people don't think about, and I guess that's to some degree where lawyers are handy, because having created a lot of contracts, we see the different areas and what can go wrong and how it goes wrong. I'll give you an easy example. One of the things I like about LLCs is that you have an operating agreement. That operating agreement is where you can turn around and state what will happen. For example, let's say if one of the members or the managing member gets sick, disabled, dies. What if that person's wife or husband is their heir? They get everything that person had. And that is the spouse from hell who hates you, doesn't know business, and is now going to be the single enemy that will destroy your company. You're stuck with them. So unless you wrote a provision in your operating agreement as to what should happen in case of disability or death, you're stuck with that. So think of everything that can possibly go wrong and offer proposed solutions to it. That's the essence of a great contract. Now, there are a number of things that should be in every contract, and those are standard clauses that you can copy and paste. And some of the clauses that you want to keep in mind are venue. If something goes wrong, which courthouse do we go to? Is it in your city or is it in their city? That's a big deal, because if it's in their city, they can file a lawsuit for the heck of it, force you to travel, like let's say I'm in San Diego here, somebody's in LA. Venues in LA, you have to travel to LA, which is not the easiest thing, as you probably know, and ruin your day in driving and spend half of it on the road, and then have to go to a court appearance or get a hotel overnight if it's an early court appearance for a simple case, a simple motion, simply because they know that that has strategic power. Because at the end of the day, whoever has the best strategist wins, whether it be in litigation, contracts, or any other area of law or business. It's about a game of strategy. So you want to have venue in your city. The other thing is, in the standard clauses, a lot of people have arbitration clauses. Remember, there's good and bad to everything. So there are choices you must make. If you have an arbitration clause, great. Something goes wrong, and everything is decided by arbitration, which is faster, it's less expensive. But if you want an award, a large award of punitive damages, you're probably not going to see them in arbitration. You're going to need a jury trial for that. So you may want to split up the issues. You know, if this happens, it goes to arbitration. If that happens, it goes to a jury trial. Or what if somebody doesn't pay somebody and they've got their intellectual property rights? You want to be able to file an action immediately to prevent them from using something that they haven't paid for. You're not going to get that through arbitration. So there are a number of factors to consider with respect to that. Another standard clause is counterparts. You know, each of you has a contract, they're both valid. You don't have to have that single one piece of paper as long as both of them are signed. Electronic signatures should be fine. Another standard clause is what's called the integration issue, that there's nothing outside the contract that you've agreed to, that everything is within the contract. Again, it's good and bad. There may be something that you both assumed, but guess what? The minute the relationship falls apart, that assumption is gone, integration clause holds, and only what's in the contract applies. Another standard clause that you may want to consider is the definition of every word, because the biggest problems that I see in our litigation department is what goes on with respect to translation, in the sense of if I say something, it means one thing to you, but it may mean something different to me. And stay away from general terms such as a reasonable time. Define everything. What's a reasonable time? If you're working in a hospital, it's probably 5 minutes if you're in the ER. If you're working at a restaurant, it's probably 15 minutes. If you're working in a law firm, it could be an hour. If you're working in construction, it could be a week. Reasonable time. And then be careful if the other side puts in very stringent clauses. For example, let's say you're a software developer. You're creating a software, but you're also going to use the basis of that software for a separate project that you're working on. I saw a clause where one company, for very little money, wanted somebody to take all of their life experiences in a certain, very specific niche area, and they were going to own all of that because the project was being built based on all of that experience and work that was conducted before the company got hired. And then the person was not able to use it for anything else. So when it comes to intellectual property, you know, items that can be copyrightable or patentable, be careful what you do and how you deal with the issues of who owns the copyright and for what purposes, because you could also license something rather than giving it away completely. And you can license it, for example, actors do this with their pictures. They're licensed for this use or that use, but not for this use or that use. So controlling, what am I talking about really? Controlling very narrowly what you're giving away, for what purpose, for how long, and how much that costs. That has to be well defined. Be careful of very strict contracts. For example, I saw a contract where there was a penalty provision if an email wasn't responded to in 4 hours. Well, if you have to respond to an email in 4 hours, that means regardless of what you're doing at work, you need to check emails on a regular basis. It may also mean that you may have to hire extra staff. to deal with that email. So provisions of that nature are very key. Another contract, something that we're just working on right now that is very interesting. Let's say somebody owes you money, but you don't think that they're going to pay. Why don't you create what's called a consent judgment, where they're basically stating, I promise to pay you X, here are the terms, but if I don't pay you, this is automatically a judgment. Get it signed by a judge, by the way. And now, instead of spending $100,000 in litigation, hoping you can find the person or company because they may have changed countries, which happened in this case, you automatically take it to court and cost you just a little bit of money to create all the paperwork necessary, and then all of a sudden you can seize their assets from their bank accounts. So as you can see, there are a number of different contracts that you can create for a number of different purposes. But one size does not fit all. If there's anything that I can tell you that I have found, and I've created contracts for several $100 million, if you try to think of everything that can possibly go wrong in that area, and the best way, if you're trying to save money not having a lawyer create a contract for you, hire a consultant in that specialized area for an hour or two, say, and have them educate you in all of the things that can possibly go wrong in that area. Because what gets most of my clients is not what they do know, it's what they don't know that they don't know. So there's no way of you possibly knowing what you don't know. Therefore, you can't possibly protect against it. But again, have your standard clauses in place. As I mentioned, there are a set of them, venue, timing, make sure that you talk about when it's supposed to be executed. Make sure that you state how long. That's another thing, by the way. A lot of my clients state, okay, redo my kitchen cabinets. I'm just using an example. I will pay you $24,000. You're going to do this. But they forget to state that it has to be done in a certain amount of time. Or they forget penalty provisions. Let's say, for example, you're about to sell the house. You're putting it on the market in 2 months. Kitchen cabinets should not be done the day before the house goes for sale. Worse yet, it could be done a week after it's for sale. You can't even get pictures of it. So, the time for execution, the penalties for not following on time, the payment method, get your deposits, because a lot of times your deposit may be the only money that you see. So in that case, if you're doing something that's performance-based, state the milestones, what will be performed, how long you have to wait for that money, and what are you going to do if it's not paid. So keep these things in mind, and at the end of the day, I wish you luck with whatever contract you are creating, but be very careful. And one last thing on that note, by the way, and lawyers are the worst for this. Somebody turns around and sends you a massive contract for a lease, a purchase, whatever, and you don't read the document. You figure when it's 54 pages, we'll just sign the bloody thing. There's nothing I can do anyway. Well, most anything is negotiable. Not everything, but most anything is negotiable, and at least to a certain degree, and at least if there's some money involved and you're willing to make certain compromises to get something that you're looking for. Read the contract. Get to know what the spirit of it is. Because especially today, where I'm finding most problems my clients are having are with the commercial leases they sign. They're signing 3- and 5-year leases for properties. All of a sudden, their needs change. Maybe they're expanding, or maybe they're contracting. But guess what? They are stuck to the terms of the original lease, and they can't get out. They can't rent it to somebody even for a lower rent, or the lease doesn't even allow them to sublease their property. Now what? And I've seen some people have to file bankruptcy over that. Why? Another provision, the personal guarantee. Be careful, especially if you're a new entrepreneur and somebody wants to sign on behalf of a corporation. If it's a well-known publicly traded corporation, that's one thing. And even then, check it out. But, if somebody's conducting business, they do it under a corporate name. they're not personally guaranteeing anything, you're at risk. Corporation, they can simply dissolve it, get rid of it, start a new one, and you're done. So, look for personal guarantees, just like landlords are getting them now from most of their tenants. You should look for personal guarantee for whomever you're working with. Now, these are some of the many terms that are required in a contract, and when I have a little bit more time, I'm going to expand and make it Contracts 201 and go into some more detailed things. But I think this introduction, if nothing else, will open your eyes into what it takes to create a magnificent contract. Because regrettably, many people that I have spoken to as clients or potential clients never took it seriously. They set up a partnership and they didn't bother filling out more than 2 pages of information. And now they've got a company that's worth, $100 million. Literally, I've seen this with a 2-page partnership agreement. The partners are at war with each other, and now what? Where are you going to go? You're going to spend the next 2-3 years in litigation. You're going to spend hundreds of thousands of dollars fighting over something, which simply in one sentence could have been taken care of at the onset. So, if there's anything that I can do to help you, I would suggest it be that take your contract seriously and realize they are the foundation. Would you rather have your future built on a foundation of concrete or grass? It's your choice. Really, the more solid it is, the more you cover what we call the 4 corners, and really get it tight, really integrate everything that you need to have in that contract. If you don't want it modified orally, you have to put it in writing. If you have to create a new contract, if there are any material changes, put it in writing. Material means something really critical, really important. Why don't you define under the definition section, these things are material, so that you've distinguished what is material from what isn't material. Or, for example, be careful of this one. This happens a lot. And oftentimes you don't see this provision in a contract where it states, okay, this person was 30 days late and you overlooked it on a payment plan. Now, because you're 30 days late, they're going to be 30 days late again. And now you're stuck overlooking it again. So you'd also like to state in your contract, if I've overlooked something, forgave something, or didn't act on something that you did, that you said that you would do, it doesn't mean that I will do it again, or that it implies that it was okay in the first place. So again, there are a number of other provisions that you can add. I'll be showing you some samples next time and going through a few actual contracts and explaining to you in greater detail what's involved. But for now, I think you've got enough to, hopefully, inspire you to write a rock-solid contract and, again, cover everything that can go wrong. Because guess what? Those who don't litigate. It's that simple. Good luck to you in whatever venture you have, and we'll see each other real soon. Have a great day.